The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to this docket. I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call this morning's case.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Thursday, May 27th, 2021 consists of one case. Appeal number 122895, State of Kansas versus Mondale, Leon Douglas, Wyandotte County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Mr. Douglas appears through Michelle Davis. I am present and ready for argument.
Madam Chief Justice, may it please the court, the state of Kansas appears by Wyandotte County Assistant District Attorney Daniel Obermeyer, present and ready for arguments.
Thank you, counsel. Ms. Davis, you may begin your argument.
The evidence in this case was that around 10 p.m. on an evening, a neighbor heard loud, I think she called it, quote, really loud and screaming argument between 2 or 3 men, and followed by multiple gunshots. The next morning, 3 deceased men were found in a house in Kansas City. And the state very quickly focused on Mr. Douglas because the casings that were found at the scene were of a very antique, not common caliber. And a detective went to Cabela's, the store in Kansas City, and was able to determine from video footage and records that Mr. Douglas had purchased ammunition that day that was used in the shooting. Also, the state presented video surveillance showing Mr. Douglas leaving. The shooting was approximately 10 o'clock. Mr. Douglas leaving his apartment building around 9:30, headed in the direction of the house where the shooting took place, and then returning to his residence around 10:30 p.m. In addition, the cell phone, 2 of the victims' cell phones had tried to contact Mr. Douglas's cell phone through calls and texts to his phone. This case was based on very circumstantial evidence. That was basically the evidence in this case based on Mr. Douglas's movements, also after and taking items to the trash. And then the state, there was some gunpowder on a jacket that was found in his closet, which the defense dismissed, saying, we don't know when the gunpowder got there, but that was basically the evidence. And so the defense in this case was, the state, reasonable doubt, the state had not proven that it was Mr. Douglas who committed these shootings. On that basis, and I think the issue that I want to focus on from our brief is the failure to instruct on lesser included offenses.
Ms. Davis, before you get there, you said something in your recitation of facts that I want to make sure I'm clear on, which had to do with the purchase of the ammunition at Cabela's.
Yes.
The way I heard you say it was that the state proved that the actual ammunition that he bought at Cabela's was what was used at the shooting, as opposed to he happened to buy the same unusual caliber, I'll admit that, but just had bought the same bullets like the ones that were used at the shooting. You see what the distinction I'm trying to, and I just want to know whether there was something I missed in the evidence, because I was under the impression that it was just similar ammunition as opposed to the ammunition.
No, you are correct. And I need to clarify my statement. You're correct. Absolutely well stated. Was the same type of ammunition. So basically the state was relying on that only, that he happened to purchase a box of the same type of ammunition that was used in the shooting. It was not the same ammunition. So,
and isn't that distinction somewhat important on your prosecutorial error argument about where the prosecutor said something similar, but we know this is the bullets that's different than saying we know it's the same type of bullets or.
That's
whatever.
correct. And I think what bothered me most about the closing argument is that this was a very circumstantial case and there was no direct proof. And so I think that in the closing argument, the prosecutor kind of tipping his thumb on the scale and saying, we know, is vouching, is kind of pushing the jury across the finish line here, is saying, we know. This is all, there's a lot we don't know. There's a lot we can't show you, but we know this. And using those words, we know, instead of this is what the evidence shows. So, for example, at one point he says, he's talking about how the people, a man was shot, and then the bullets were unloaded, and then and then they were reloaded. But he says, he doesn't, instead of saying, we know that 4 bullets were fired, and then the person unloaded the bullets, and then 4 more bullets were fired. He says, Mr. Douglas fired those and then unloaded. And then he says, we know he fired at least 4 more. Well, we don't know that he fired at least 4 more. We know that 4 more bullets were fired. So there's a difference there. There's a difference saying this is what the evidence showed and saying we know that Mr. Douglas. So that's the part that bothered in the closing argument. So thank you for that correction. You're correct. It was this association. And of course, the defense in this case is there's other stores, not necessarily close by, but there were 2 other stores in Missouri where you could get these ammunition. And apparently there was an internet. You could also get these on the internet. There was a provider of this ammunition. And apparently also that somebody else had purchased, Cabela's had sold other boxes of this ammunition in the preceding 6 months. It wasn't a lot, but they had sold 2 other boxes in the preceding 6 months. So the defense pointed that out. Going back to the lesser included, the judge in this case, there was a discussion off the record before they went on the record. And so I think the statements of the judge and the defense counsel kind of mirror each other. And they basically use the language, the defense did not request any lesser included offenses, staying, and the state's pointing the fact that counsel said, and indeed there may not be any applicable ones either. And that's what the judge pretty much said. The judge noted the evidence that there had been this loud and heated argument. And the judge said, but he didn't believe there were any applicable lesser included offenses. So, you know, it's our contention that clearly.
Ms. Davis, can I clarify something?
Uh,
I thought counsel stated, I am not requesting any lesser included offenses. That's a little different than what you said. Is that what counsel said? And
That's right.
That's so that in the context of when we're talking about whether they were requested or not requested, or why is that I'm not requesting lesser included. And what's the impact of that when counsel is specific representing Mr. Douglas is saying, I don't want lesser included instructions. What's the impact of that?
You know, I think we're still under the clearly erroneous standard because it's still the judge's obligation. These were not requested. Defense counsel is focused on, my client didn't do this. That's his defense. He's not focused on a lesser as a defense. Lesser included offense as a defense. In some cases there is, that is a defense, right? So, but the judge still has an obligation to instruct on any crimes that are supported by the law, independent of counsel not requesting it. The judge still has to say, there's evidence here to support that, I need to give it. Now, if defense counsel then override.
Yeah, maybe you were going right where I was thinking, but what if defense counsel objects?
Right, if defense counsel then pushes it and says, yes, there is some evidence here and you have a duty under Kansas law to instruct, but we're going to ask you not to as a strategic reason. We want to go all or nothing. Then I think you're getting towards invited error there because everybody's acknowledging the instruction is warranted, but I'm making a strategic decision not to do it. But we don't have that in this case.
Do you think that's still error? In other words, you're saying the law actually prohibits a defendant from going all or nothing?
No, I think we're just into the states trying to argue this is invited error.
I know, but do you think it would still be error for a judge to accede to a defense lawyer's request not to give a legally appropriate lesser instruction?
My understanding under Kansas law is yes, that the judge is required to do it. And then under the strategic situation, this court just will not review it because the defense counsel has led the court into that error.
Well, what happens if the court gives a lesser that the defense objects to, and then the issue on appeal is, hey, why did you give the lesser? You overrode our defense, which was all or nothing.
Yeah, I haven't thought about that situation. I haven't seen that too much. So the judge wants to give the lesser and defense counsel objects. And then on appeal wants to challenge it. Is that your scenario?
Yeah, it just seems to me that we've created a circumstance where there's an appealable issue either way. And so it's almost a no-win circumstance. And we seem pretty close to that here.
I don't think so. I just don't think we're in that situation. I think defense counsel was just so focused on his defense and not on whether the evidence supported this. And that's the judge's job. And clearly the evidence did support it because it at least supported an intentional second-degree instruction. The fact you had this loud and heated argument supports that this was a spontaneous, passionate act.
But wasn't the whole defense here that it wasn't my client?
That's right. That's right.
That would support a strategic decision to go all or nothing.
But we just don't have a record. The record doesn't support that. If this court
except for the fact that the defense attorney said, I'm not requesting lessers.
That's it. That's it.
Okay.
But that's not getting us to a strategic decision.
Ms. Davis, is there an instance where intentional second degree is not a lesser included of premeditated first degree murder? We've had these whole line of cases talking about the propriety of lesser includeds. And it seems to me that it's pretty close, at least where the court stands now in its precedent, that it's almost always required. Would you say that's true? Where do you think we stand with that?
I think you're right, because intentional is a culpable mental state for both crimes. And then premeditation is the additional element for first. So yes, it would fairly much be required as a lesser included offense. And in this case, the evidence supported it. I guess it's always legally required, Justice Rosen.
I'm talking about factual. I'm sorry, I should have clarified factually.
Factually required. The state.
It seems to me that we've kind of gotten to the point where, at least in this instance, when we're talking about premeditated and intentional second degree, it is almost always factually appropriate, given our standard.
Yeah, I think unless the state had some kind of overwhelming evidence, like a confession, would be the only situation I could think of. But even then, I think the way this court has structured the law, it still needs to be given. It's still a choice for the jury to make because the evidence does support it. And that's the way Kansas law is written. So I guess then you get to the harm, whether it's reversible or not under your point of view. I think in this case, sure, there was some evidence of premeditation in terms of the going to buy the similar ammunition. But there's also evidence, the argument also supports, and this was a loud, you're talking about a neighbor hearing a really loud and screaming argument. That's circumstantial evidence that also supports that this was simply intentional, and also supports heat of passion, sudden quarrel. That type of argument, the way the neighbor described it, is circumstantial evidence. And the state's going to say, well, we don't know what happened. And that's true, but we don't know what happened in terms of premeditation either. All we have is circumstantial evidence that you can draw from. So if you can draw circumstantial evidence of premeditation, you can also draw circumstantial evidence of the lesser included offenses.
I think the evidence of premeditation seems to me to be pretty strong when you add in the type of gun that was used and the fact that it had to be reloaded, and you've got the little shell casings in discrete areas around the house. I mean, somebody was intending to make sure that they put several bullets in each of these victims, so that premeditated evidence gets to be really, really strong. I mean, I understand your argument when you're trying to make the connection between all of that and Mr. Douglas.
Mhm.
But the premeditated crime aspect of this seems pretty substantial.
Yeah, but my understanding is that guns fire pretty quickly, and it also supports somebody who's very, very angry. He's very, very angry, repeatedly firing. So it also supports that inference.
Except you got to pause, reload, and then stay really, really mad through all that and not form an intent to kill. So
You're right, but I think if you're talking about a really loud and screaming, the word screaming was used, argument, then I think we're there. We're talking about an intense emotional state here. I'm just simply saying this was an option the jury should have been given. There was enough here that a jury looking at this evidence, this was a difficult case for a jury, very circumstantial, very serious charges. And the jury should have had that option of intentional second. And I can see that I'm out of time.
Are any other questions? Thank you, Ms. Davis. Mr. Obermeyer?
May it please the court. Your honors, this was a circumstantial case, but as the judge noted in denying the defendant's motion for a new trial, this was an incredibly strong circumstantial case. Counsel's review of evidence was succinct. I'd like to add a few more points for the court's consideration, just to emphasize exactly how we got to where we are procedurally, especially with the lesser includeds. First, the evidence was that the defendant began looking for ammunition at Cabela's around 3:47 p.m. This is not a controverted fact. It's on video. It's not controverted that he bought the box of these 3220s of this specific made at Cabela's, and then that he went home to his apartment in Kansas City, Kansas. Video surveillance also confirmed him going to a nearby liquor store after he came back from Cabela's, ostensibly drinking some beer beforehand, and then around 10 p.m., heading over in the direction of the victim's houses. Now, at the victim's houses, we have evidence that 3 individuals were murdered there, and the details of that are quite, I think gruesome is an appropriate word. They were each shot multiple times, each of them once in the head. One of them was shot 3 times in the head, and another of them was shot once in the back. So, as Justice Biles noted, the unique caliber of this ammunition indicated that it was a revolver, and the detective who noticed this unique ammunition testified that that would have required whoever killed these 3 men to reload at least twice in the course of these murders. Now, that's overwhelming evidence of premeditation, and I think that the record is clear. That's why I made the invited error argument in my brief that defense counsel was indeed going for an all or nothing defense, that the undisputed facts of this case were that these 3 men were murdered, that it was premeditated, and happened in Wyandotte County on this date. Now, given that information, the only real question we have is who did it, and again, the evidence in this case is overwhelming that the defendant is the one that committed these crimes. So I would ask the court first to find that the issue of whether or not voluntary manslaughter and intentional second-degree murder are properly preserved for this court. I would ask that this court decline to address those. However, if this court does address those on the merits, then I would submit that neither of them meet the court's test for clear error in this case, in which the defendant has to show that there is no reasonable probability that the jury would have reached a different verdict had these instructions been given.
Counsel, let me get you on the invited error issue before we move over to the rest. I mean, the problem the court has had with various state prosecutors wanting to argue invited error are sort of the 50 shades of gray that happen during instruction conferences. And the state kind of wants us to project where the defense was headed without having solid evidence that they were in fact headed there, if you get what I'm saying. I mean, it seems to me this is one that would, when you're trying to preclude a defendant from actually presenting an issue, you need something fairly solid. And in this case, the judge says, well, what do y'all think about instructions? Defense says, I don't want to have any lessers. The state says, or I wasn't going to request any. The state says I wasn't requesting any. And the judge says, well, I wasn't going to give any. It doesn't seem like there's a cause and effect from the actions of the defense to preclude these issues in a very serious case from being presented. So what's the trigger point for you, if you will? What did the defense do to cause the judge not to give instructions that this judge said he wasn't going to give anyway?
Well, I think that certainly that would support a judge's decision, whether it might have changed the judge's calculus. Again, that's speculation on my part, but I think it's reasonable. The judge in this case is very familiar with this court's precedent, as essentially as Justice Rosen pointed out, that second-degree intentional is almost always given when premeditated murder is the crime. So I think that had defense counsel seriously argued for and fought for intentional second-degree murder, that maybe that would have changed the court's calculus. Maybe it would have helped the court see the evidence in a different light. But that's the role of defense counsel, to make the case before the district court, who has already reviewed the evidence and who is there to make the right call at the right time. So that would be my submission as to why this really is something that trial counsel invited. So maybe this court should respect that decision and decline to second guess defense counsel and the court's decision based on what defense counsel said at the time.
Do you find it significant that the questions asked by the court, do you believe any lesser included offenses are applicable, or are you requesting any? And the response is, I know that I'm not requesting any, and there may not be any applicable ones that even apply anyway, or something to that effect. I mean, does the latter part of that statement add some context to what's going on here? In that, I don't know, is it fair to read that as, I know I'm not going to request one, whether or not, even if some apply and are appropriate in this context? What's a fair reading of that response from Mr. Rook?
I think that defense counsel's a fair reading of that would be, well, yes, we know that these crimes were committed, these 3 people are dead, and the evidence is such that I, as a defense counsel, I can't reasonably argue to a jury that this was anything less than premeditated, or that this was merely intentional. So again, I can see him making that decision. Like that to me is a fair reading, that he is choosing based on the evidence, not to sort of diminish his credibility by arguing something which is not supported by the evidence. And I think that if I can use that as a segue into the clear error analysis, if defense counsel, in reviewing this evidence and listening to the testimony and seeing the state's exhibits, thinks that there is no reasonable probability that the jury is going to convict on a lesser included, I think that that's a fortiori to the state's point that this is not a clear error situation. So we would ask the court to, if it does find that the district court erred in not automatically instructing on second-degree intentional murder, and then furthermore on voluntary manslaughter, to find that the defendant has not met their burden to show that this is clear error. Moving on to the issue of prosecutorial error in this case, there is one thing I feel like I should address in counsel's arguments. The part where and I believe this is on page 522 of the transcript, where she's arguing that the prosecutor is saying that we know that the defendant shot this many times. The full context of that statement is a very long sentence. It says, that's Mr. Douglas shooting these men 6 times, pausing, dumping out those rounds, which is why they're in a nice neat pile outside. Then he went in, fired 6 more, dumped that pile, and you see that in the hallway. Then he fired, we know, at least 4 more. So I think that there's 2 ways that you can read that. You can read that as the defendant would urge you to read this, that the emphasis for the we know is on the he fired rather than on the number of shots fired, which I think is a more reasonable reading of that statement. In the full context of that sentence and even of that paragraph, it's the way that I read it, he's drawing attention to the number of shots fired, which again was not in controversy in that case. So under the test set forth in King, I would submit that from that point of view, he is arguing an uncontroverted fact based on the number of shots. Now, defense counsel's argued that a jury could reasonably take that another way. This is where I would ask the court to adopt language, which I cited in my brief from the United States Supreme Court. And the gist of that language is just because a damaging meaning can be put on a prosecutor's statement doesn't necessarily mean that it should be put on the statement. And the court furthermore shouldn't assume that a jury will draw that meaning out of a plethora of different meanings. So
who
Yes,
who is the he? Who is the he in that statement?
the we in that statement, I believe from the context
No,
of that,
not the we, the he.
oh, I apologize. Well, the he in the first clause, or in the second clause of that sentence, I believe is referring to Mr. Douglas.
And so isn't that the problem? Not the 4 shots, which may very well be uncontroverted, but whether the shooter was the defendant is controverted. That's the entire that's the entire controversy of the case, isn't it?
Yes, Justice Stiegel, and that's why I say that it can be reasonably interpreted that way.
Can it be interpreted any other way? I mean,
well,
in other words, if the prosecutor had said, we know that the shooter fired 4 more times, that to me all of a sudden looks far more uncontroverted. But the fact that the prosecutor said, we know that he, the defendant, fired 4 more times, that's where the we know becomes problematic, right?
yes, I agree with that. But if I could, if you look at the sentence that he's arguing is perfectly permissible argument right up until the point he says in the last 5 words, and we know at least 4 more shots fired. So up until that point, the prosecutor's making permissible argument. No one's contesting that those are reasonable inferences from the evidence. But this court has said in King that the prosecutor cannot use we know to argue reasonable inferences. But I say, but for that, we know at the end of that long sentence, this wouldn't be an issue before the court.
So you're saying that the he referenced by Justice Stiegel can be interpreted to transform to a generic he, as in whoever it was, he.
In the context of that sentence, I think that I have to concede. He's saying the prosecutor's arguing that's Mr. Douglas shooting these men 6 times, pausing, dumping out these rounds. Then he went in 6 more. So I don't think I can argue that that's a generic he in the second clause of the sentence. But if we're talking about but my argument is that that's permissible argument right up until he says we know. And I think that the prosecutor was very careful in his argument to try to use we know only on uncontroverted facts. So this, as far as all the issues presented, of all the many times he used we know and you know in his argument, that in my reading is the only problematic one. But it's not. I would argue that this was a harmless prosecutorial. If this court does find prosecutorial error on that this is harmless in the context of the entire state's case. Again, the strength of the evidence is very much overwhelming. The defendant knew these people. The defendant was heading towards these people's house. That he had planned this out in some way for hours before that it happened, and also indicative that that this didn't really have any weight in the minds of the jury. The jury did not immediately return a verdict. Instead, it broke for the evening after asking a question. The next day, it asked a question, and then it only at that point was it able to reach a verdict. Furthermore, the jury was instructed that statements and remarks of counsel are not evidence. So I would submit to this court that indicates that the jury did not let this one errant we know influence its verdict. Unless there are any questions from the court, I would ask that this court affirm the defendant's convictions and sentence. Thank you.
Are there any questions? Thank you, Mr. Obermeyer. Ms. Davis, you reserve 3 minutes.
I just disagree that there was overwhelming evidence here. If you look at the defense counsel closing argument, he points out that there was drug paraphernalia and drug activity at the house. And he pointed out that violence is associated with drug activity. So simply walking towards somebody's house at around the time of the shooting is not proof beyond a reasonable doubt. The evidence here is very questionable in terms of whether it meets the reasonable doubt standard. And the error by the prosecutor in this case, where he several times used the expression we know, it has a cumulative effect. So then at some point, even when he's saying, and he pointed out the uncontroverted evidence with we know, it's ringing in the jury's, the earlier erroneous ones where he's making claims that aren't supported by the evidence are just magnified.
Ms. Davis, you would concede that the state doesn't automatically err every time one of these prosecuting attorneys says we know, right?
That's correct. If it's definitely evidence that's established, right?
But we always have to look at in detail the context that the we know is stated so that we can figure out, well, like that third example, whether it's the he fired or the pile of bullets that we're talking about.
I understand the state's argument here about context. I understand that. But one of the statements that he made was, but we know what he did. And then the prosecutor goes on to say, well, we know and it had something to do with the trash and the uncontroverted evidence, but making a declaration, we know what he did. This is very dangerous. And so then later going on and talking about things that are uncontroverted, you can say, well, this is all okay because it's in that context. But the seed has already been planted in the juror's mind. There's a vouching there that's already taken place. And that's what's really dangerous about making that kind of claim. And frankly, this prosecutor needs to stop doing it. He needs to be saying the evidence shows, our evidence supports. Those are the statements the prosecutor needs to make. He's throwing this expression around way too freely.
Now, so what if every instance of we know was changed to we argue, would you have a problem?
As long as you don't have the vouching, the prosecutor putting the weight of the state behind it.
So we argue is okay.
It's our argument or it's our contention. Yes, I could.
So I guess my follow-up question goes then to harmlessness, because we have already said that you can't say we know when it's not uncontroverted. So that is error. But when it comes to harmlessness,
I think that definitely, given the evidence in this case, it was so circumstantial this error would definitely harm the defendant because again, it's easing the jurors' minds. The state believes this guy did it. The state's telling us this guy did it. The state's saying we know this guy did it. So I can go guilty.
Last question, just colloquially, is there really that much of a difference between we know and we argue? In other words, doesn't the jury understand that, of course, the state is making this argument? That's their case.
Right, but from watching television shows, there's always this, the state knows something, but they can't prove it in court or they can't bring it in court. There's evidence they can't use in court. They've heard something on the street or they have people on the street that are telling them this. They just can't use it in court. So that's in people's minds. They're saying, this is all the evidence we can give you, but we really know. So if it wasn't for Hollywood, it might be okay. But unfortunately, television creates a lot of fiction. So, and that concludes my time. And we would ask that you reverse Mr. Douglas's convictions and grant him a new trial.
Thank you. Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement. We are now